You are owner.
I am the truck driver and the owner of the truck. While the
You are truck owner and driver.
my lord, sir,
इनके साथ अगर विटनेस आएगा तो आरटीओ कार्यालय का क्लर्क आएगा, इनके साथ तो थोड़ी आएगा ड्राइवर.
even if my lords, I'll separately call the auto driver, my lords. Petitioner's case before the claims tribunal is that the accident occurred due to the fault of the auto.
You are owner.
I am the truck driver and the owner of the truck. While the
You are truck owner and driver.
my lords, while the truck auto driver and its owner has been left out and have not been
Who is
impleaded.
injured?
My lords,
Who is the injured? Deceased.
my lords,
कौन है deceased?
disease is the wife of the respondents.
She was traveling in the auto.
My lords,
And you said some account of negligence of the auto driver.
my lords.
So what do you want to get produced?
My lords,
क्या समन कराना चाहते हैं?
documents regarding the auto drivers and its vehicle, my lords.
From where?
From the possession of RTO, my lords.
Let's see your application.
My lord, kindly appreciate Annexure P3.
Hmm.
The only ground for rejection of my both the application is that they are not party before the tribunal, therefore the application cannot be considered. P3 is at page 24, my lords.
This is your defense. You can prove the defense.
But my lords, for a moment, kindly consider that, my lords, the judgment 1995 judgment.
नहीं, आप प्रोड्यूस कराना चाहते हैं पंजीयन प्रमाण पत्र, परमिट, फिटनेस,
My
बीमा,
lords,
चालक का ड्राइविंग लाइसेंस,
My lords.
की यात्री क्षमता,
My lords.
यात्री पंचनामा, निरीक्षण
My
रिपोर्ट,
lords.
तो चालान के साथ होगा ये सब, वहाँ से प्रोड्यूस करा
नहीं है ना सर उसमें. That is why.
No, the auto must be registered somewhere. Registration is not in dispute.
My lords,
Permit and fitness.
my lords,
So how that is led to the accident? Because this claim is not against driver of the auto,
My
owner
lords.
of the auto.
my lords.
So how that is relevant?
My lords, may kindly appreciate, my lords, I have in my written statement.
Driving
stated-
license of the, if the minor was driving, that might be relevant.
My lords.
But then you can prove by your evidence that minor was driving.
But for raising the evidence, there has to be an issue, my lords. We have raised the issue before the claims tribunal in our written statement that the accident occurred due to the fault of the auto driver.
देखिए वाहन की यात्री क्षमता से संबंधित विवरण,
My lords,
ये तो आप मैन्युफैक्चरिंग कंपनी के किसी रिप्रेजेंटेटिव को लोग लाके एविडेंस करा सकते हैं.
my lords,
ऑटो रिक्शा की क्या क्षमता होती है?
my lords, may not be the वाहन क्षमता document, but the driving license.
ड्राइविंग लाइसेंस कैसे आएगा? आरटीओ को कैसे मालूम पड़ेगा कौन ड्राइव कर रहा था उस ऑटो को? आरटीओ के पोजीशन में तो 1 लाख ड्राइविंग
The
लाइसेंस.
registration certificate of the auto, whose name the auto is registered, and the driver and the owner.
Relevant. You can say that auto was negligent. Auto was driven by a minor. Auto was being negligently driven.
My lord.
ऑटो के ओनर के अगेंस्ट तो कोई नहीं है ना
नहीं,
claim.
no,
Claim is against the truck owner. So you can only raise the defense that the auto was negligently being driven.
my lords. While crossing the road, my lords, the auto collided with the truck, my lords.
So that is to be proved by ocular evidence. And if it was driven by a minor, then you can prove by other evidence.
Lords, kindly consider one thing, my lords. The auto driver, in absence of the impediment of auto driver and its owner, my lords, how can raise the evidence?
No, you can take the defense. उन पे liability cast नहीं होगी. अगर तो आपको तो अपने से बचना है ना. आप क्लेमेंट थोड़ी हैं. आप क्लेमेंट होते तो ये बात ठीक थी.
But that is why, my lords, I have moved an application under order 1, rule 10, sub rule 2.
They are not necessary parties. You can take your defense.
My lords, kindly-
You don't want the responsibility to be cast on them.
my lords,
You want you to be exonerated.
that is true.
देखिए अगर if you are claimant, then you are right.
My lords,
That since there is contributory negligence of the auto rickshaw,
my lords.
so the auto rickshaws driver and owner are necessary parties.
But
But you want yourself to be exonerated.
My lords,
For that, how they are relevant?
But my lords, another part of the order is that my right to adduce evidence has also been forfeited by
वो कहाँ है
this
बताइए?
order, my lords. इसी order में देखेंगे सर, पेज 18 पे पुनश्च करके कल फाइनल आर्गुमेंट के लिए लगा दिया है. एंड दैट इज व्हाई my lords, 110 की एप्लीकेशन.
नहीं तो आपने घोषित कर दी साक्ष्य समाप्त. देखिए
my lords,
आप ही ने घोषणा कर दी कि हमारी समाप्त हो गई. अनावेदक क्रमांक 1 व 2 की ओर से अपनी साक्ष्य समाप्त घोषित की गई.
my lords, नियत है and घोषित की गई एंड टुमारो इज फॉर द जजमेंट, फाइनल आर्गुमेंट एंड
देखिए
जजमेंट. my lords,
प्रकरण अनावेदक क्रमांक 1 व 2 की शेष साक्ष्य हेतु पुनः नियत किया जाता है.
my lords,
शेष साक्ष्य हेतु पुनः नियत हो
my lords,
फिर बाद में
पुनश्च करके.
आपने क्लोज घोषित कर दी.
my lords. But for a moment, my lords, kindly appreciate the judgment, my lords, 1995, my lords. With regard to order 1, rule 10, sub rule 2, my lords. Para 7, that was my application. Only para 7.
No, you can call these persons through process of the court in evidence.
That was another application, my lords, under order 16, rule 6, my lords. That
कहाँ-
has also been rejected, my lord. Annexure P3 is the application, my lords.
And nobody will give a evidence against himself.
That is the problem. That is why I have sought impleadment of them, my lords. So even if, my lords, I will raise the defense that the accident occurred due to the fault of the auto and auto owner. So, my lords, the entire liability will be imposed on me because they are not party before the
You can
tribunal.
prove that it was their negligence. How you cannot prove in their absence?
Para 7 of that judgment will be seen, my lords. 1995 judgment, my lords. This judgment is, my lords, Anil Kumar Singh versus Suna. Para 7. Married, my lords. By operation of the above quoted rule, in para 6, my lord, the rule 10, the rule is quoted. By operation of the above quoted rule, no, the court may have the power to strike out the name of the party in property joint or add a party, either on the application or without application of either party. But the condition precedent is that the court must certify that the presence of party to be added would be necessary in order to enable the court to effectively and completely adjudicate upon and settle all the questions involved in the suit. Bring a person as a party defendant is not a substantive right, but procedure in the court and justification and its proper exercise. Now, my written statement may be seen, my lords. The written statement would allow the amendment, my lords. In the written statement, we have categorically pleaded that the accident occurred due to the fault of the auto driver because it was overloaded, my lords. So, my lords, in absence of they being a party before the tribunal, what is the relevance of my?
You can prove the sanctioned load by other means also. आप आरटीआई में उसके डॉक्यूमेंट निकाल लीजिए उस ऑटो के, आप प्रोड्यूस कर दीजिए आरटीओ से निकाल कर. ऐसा थोड़ी है कि उसको
as far as the production of document is concerned, my lords, I can understand the proposition of my lord is correct, but they have to be implemented as a party under 110, my lords, because the evidence has to be laid against them, my lords.
किसकी बयान कराना है, किसी गवाही कराना है, बताइए.
My lords, the auto driver, उसको हमको क्रॉस करना है बिकॉज उसकी
ड्राइवर आपके कहने से आ रहा है क्या?
नहीं, कोर्ट समन करेगी तो आ जाएगा ना सर.
तो आपकी कोई एप्लीकेशन है क्या समन करने की?
तो इम्प्लीटमेंट के बाद ही तो सर होगा ना.
इम्प्लीटमेंट थी आपकी, समन करने की कहाँ थी?
16.6 की थी ना सर.
कहाँ है?
16.6 की P3 my lords में काइंडली अप्रिशिएट. P3 पेज 24 टाइटल ही में लिखा हुआ है.
नहीं, 16.6 में आपने उसको कहाँ किया है? उसको बुलाया जाए ऑटो ड्राइवर.
सर ऑटो ड्राइवर के ही कॉन्टेक्स्ट में सर 11-14
डॉक्यूमेंट्स मांग रहे हैं.
डॉक्यूमेंट्स उसी की कॉन्टेक्स्ट में सर हमने इम्प्लीमेंट नहीं मांगा.
कॉलिंग दैट ऑटो ड्राइवर सो एंड सो वाज ड्राइविंग द ऑटो, ही शुड बी कॉल्ड इन एविडेंस. ये एप्लीकेशन कहाँ है आपकी?
My lord, the purport of the 16.6 is that only, my lord, because I have sought those documents only.
Documents is one thing, calling a witness is another thing.
But my lord,
इनके साथ अगर विटनेस आएगा तो आरटीओ कार्यालय का क्लर्क आएगा, इनके साथ तो थोड़ी आएगा ड्राइवर.
Even if, my lords, I'll separately call the auto driver, my lords. If on my application he comes before the court,
he will refuse that I was not driving the auto.
That is the case, my lords.
फिर क्या करेंगे?
That is why I am seeking the impleadment of.
Then you will have to cross examine him.
That is why, my lords.
तब भी कर सकते हैं आप उसको कोर्ट से बुला के. तब क्यों?
वो तो रिजेक्ट कर दी ना सर कोर्ट ने. 110(2) भी रिजेक्ट कर दिया इसी ऑर्डर से. इम्प्यून
इसमें लिखिए by way of this petition challenge is made to the application order dated 17/11/2025 whereby the claims tribunal has rejected application under order 1 rule 10 CPC for impeding the driver of the auto rickshaw. Owner and driver of the auto rickshaw.
At least, my lords, one more opportunity may be given to
किसको प्रोड्यूस करना है, आप नाम बताइए.
To the auto driver, my lords. I'm not aware of the
application देना पड़ेगी.
My lords, we'll file the application because tomorrow is the last date, my lords. Tomorrow is the last date, my lords.
आप application दे दीजिए ना. Who stops you?
My lord, I'll file it tomorrow, my lords, but till then protection may be given. Otherwise,
कब है फाइनल आर्गुमेंट के लिए? कब है?
tomorrow, my lords.
Tomorrow है.
इसी ऑर्डर में लिखा है P1 में. Page 19.
If you withdraw it, then we'll grant you liberty to call that. Yes, को खारिज करें merits पर.
My lord, may pass an order on merits and thereafter liberty may be.
The auto rickshaw and driver as party in the claims petition filed by the claimants. Point. Next, the case of the petitioner, owner and driver of truck is that who are owners and driver of truck is that there was a collision between truck and auto rickshaw, and it was on account of auto rickshaw being rashly and negligently driven by a person who was not licensed nor authorized to drive the auto rickshaw, and Therefore, for death of passenger of auto rickshaw, the truck owner and driver are not responsible. आपका truck insured नहीं है क्या?
That is what the insurance company is claiming.
They are not responsible. Next.
So I am hanging in no man's land, my lords.
Next.
So,
The counsel for the petitioner has argued that the petitioner wants to take a defense that auto rickshaw was being driven and operated in violation of its permit, seating capacity and other particulars as per registration, and therefore the petitioner wanted to implead the owner and driver of the auto rickshaw. Point. He further had filed another application under Order 16 Rule 6 CPC, read with Order 11 Rule 14 CPC for summoning the registration documents of the auto rickshaw from RTO office. Point. Next. Upon considering the arguments of learned counsel for the petitioner and on perusal of the report, it is evident that the petitioner wants to take a defense that there was in fact negligence of the auto rickshaw and the truck had no negligence in the accident. Point. The petitioner
Defense
can
is
very
already-
well take this defense even without impleading.
defense is already there in WS.
The petitioner can take this defense even without impleading the driver and owner of the auto rickshaw by leading his own evidence to prove negligence of driver of the auto rickshaw. Point. Next, so far as the documents to be called from RTO office in relation to registration and permit of the auto rickshaw are concerned, the petitioner could have obtained documents from the said office under Right to Information Act and by any other means known to law by paying requisite charges to the RTO office, and only if his such attempts had failed, then submitting application before the trial court for summoning of such documents could have been stated to be bona fide. Point. However, the petitioner never took any steps for getting copies of those documents from RTO office, and therefore the trial court, therefore in the considered opinion of this court, the trial court has not erred in rejecting the application under Order 16 Rule 6
May I pause
CPC,
here?
read with Order 11 Rule 14 CPC.
The reason of the trial court for rejection of my application is that they are not the party, not that I have not procured the documents, my lords.
Though the trial court has rejected the application on the ground that
They are not party before the tribunal, that is why. Page 17. Relevant नहीं है, party नहीं है इसलिए relevant नहीं.
on the ground that the driver and owner of auto rickshaw are not parties, but still the petitioner would have shown his bona fides by attempting to get copies of such documents from the RTO office, which has not been done by this court. And therefore, for different reasons, this court does not find any error in the order of the trial court. Next. In view of the above, no indulgence can be caused in the implementing order passed by the trial court. Point. Passed by the claims tribunal. Point. Next, the petitioner is set at liberty to take all his defenses before the claims tribunal, and he is also set at liberty to move application for summoning the driver of the auto rickshaw through process of the court if so advised. With the aforesaid observation, the petition is dismissed.
My lords, till such time application is filed by petitioner, my lords, before the
You will file tomorrow. Who stops you?
We'll file tomorrow, but
file
the same is rejected again and matter will be heard to that extent protection may be given, my lords.
What
At least
protection? You file tomorrow. Who stops you?
that the trial
आप
court,
नहीं है claimant की तरफ?
trial court may be directed to consult.
saying that TV copy till tomorrow 2 p.m. because कल की date है.
हाँ ठीक है.
My lords, may kindly approach, trial court may be directed to consider my application first if it will file and thereafter may proceed to take a different decision. My lords. That may be
It always happens. कोई भी आइए आएगी, पहले आइए डिस्पोज ऑफ होती है ट्रायल।
सर एक ही दिन में सर तीन
ऐसा
कॉन्सिक्वेंसेस
थोड़ी होगा कि आइए
हमारा
आइए
राइट ही फॉरफिट कर दिया।
आइए पेंडिंग रहते थोड़ी होता है।
सर उसी पार्ट को थोड़ा सा मॉडिफाई कर दिया, एक ही पार्ट हमारा एविडेंस भी क्लोज कर दिया ना, इसलिए वो एप्लीकेशन एंटरटेन नहीं करेगी।
क्लोज डिक्लेयर किया है।
तो उस पार्ट को थोड़ा सा ओपन कर दिया सर।
And if the petitioner submits such application, the closure of evidence of the petitioner shall not come in the way.
Obliged. I'm praying for city.